Good morning, everyone. Let me take this opportunity to welcome all of you to our webinar. Thanks to the panelists that have agreed to join our webinar this morning. In terms of welcome and introduction, I would like to start by saying that we are delighted that the representatives of the Office of the Pension Funds Adjudicator are joining us this morning. I would like to take this opportunity to welcome Willana Groenewald and Naheem Essop. As you know, the mission of the Office of the Pension Fund Adjudicator is to solve complaints in terms of the Pension Fund Act in order to uphold the integrity of the pension fund industry and also to protect the interest of the fund members. As you know, COVID-19 pandemic has caused financial distress for employer, and in many instances, it has created an even greater impact on their employees who may be members of the retirement funds. Therefore, one of the topics we will be discussing today is how the pandemic has impacted the number of complaints and the number of complaints that have been received, by the Office of the Pension Fund Adjudicator. This is therefore a general update from the Office of the Pension Fund Adjudicator. I thank you.
Thank you, IRF President and Chairperson. I'd like to just present the names and the positions of the two speakers. I'm sure everyone can read it. And everyone's probably familiar with these people. Thank you again for joining us. And I'd like to kick off with the first part of the discussion, and that's the impact of the COVID-19 pandemic on complaints. Willana, I'd like to direct these questions to you mostly, and Naheem, please, if there's anything you can contribute, please add in. But Willana, can we start with point one, please? And if you can just give us some info on that. The question, Jan, I'm sure everyone can see it, but I'll just read it. Has there been an impact on the number of complaints since the imposition of the state of disaster?
Good morning, everybody. Thank you, Wayne and Enos. It's really a privilege to be here and to take part of this discussion today. My answer to your first question is yes. For the months of April and May, we saw a sharp decline in the number of complaints lodged with our office, where the average of complaints per month will usually be around 800 plus. We only received 165 in April and 321 complaints in May. It must be said that withdrawal benefits and non-compliance of employers are still the main types of complaints before and after the imposition of the state of disaster. It was, however, noted that it was the type of complaints related to access to funds held in retirement annuities, preservation funds, and living or life annuities doubled during this period.
Thank you, Willana. So it's interesting that you're saying that the number reduced, but the type was different from what you usually receive. I think that the next question sort of leads to that, and the next point is, what do you think why do you think this is the case in particular, the type of complaints?
When, in general, the most preferred methods used by complainants to lodge a complaint with the OPFA are through emails and walk-ins. They are the highest the most used methods. But since the imposition of the state of disaster, that did not allow people to visit our office, it drastically had an impact for people not able to lodge complaints at our office in person. So emails were still the top method used to lodge a complaint, but we saw then a noticeable increase of complaints lodged via our website. Faxes, letters, and walk-ins came in last.
Thank you. It's interesting, and I think what this leads us to is the point 3. And I mean, as you've mentioned, that walk-ins are one of the highest methods of lodging a complaint. Obviously, with the regulations in place, what has the Office of the Pension Funds Adjudicator done to facilitate the walk-ins and allow people to use those methods of lodging complaints again?
Wayne, as from the 22nd of June, this past Monday, we are again officially open to receive walk-in complainants. However, to minimize the spread, and if possible, complainants are still encouraged to make use of alternative platforms available to lodge their complaints, being via email, our website, faxes, or even letters. When they do visit our office now, the no mask, no entry principle will apply, together with the practicing of safe social distancing, with the use of floor stickers indicating where to wait for assistance. Walk-ins will be requested to use the stand-up, no-touch hand sanitizers, and to complete a visitor register with their contact details, alongside with their temperature taken by OPFA staff with a non-contact infrared forehead thermometer. We also placed see-through desk screens at the reception desks and cubicles, which we use to assist walk-ins.
Wow, so it's nearly business as usual.
Yes.
Or business is unusual, possibly here. I don't want to preempt or say anything, but now that the facility is open, there might be the people who wanted to use this method of lodging complaints and haven't had an opportunity, and now they're going to come to your office.
Correct.
But and just as far as the sort of lodging of complaints and things are concerned, if I recall correctly, there is a statement that the office has placed on your website as well.
Yes, we did load a notification letter to all stakeholders to this effect, that we are resuming to receive walk-ins again under the latest available, due to the latest developments regarding the COVID-19. And then there we just give short guidelines as to what you should have in place when you do visit our office. If your temperature is above 37.5 degrees, for example, we will not be able to assist you, and we will suggest that you see a GP. Basically, it is the wear the mask, use the sanitizers, practice the social distancing. And then on this letter, we also provided details of our alternative platforms on which you can lodge your complaint, be via our email address, the website, like I said, faxes, or then if you want to make use of the post, you can, but that usually comes in as the last method to lodge complaints.
Yes, there's Phil on it. I see there's one question. I think it's more a statement, and I think it makes sense. It's not necessarily anything for you to respond to, but Sunil Maharaj said, I assume the increase in the complaints relating to RAs and living annuities is because more people have been trying to access funds from these investments. And I think that's probably also something we can touch on: jurisdiction, RAs, living annuities, and maybe some of the similar characteristics even preservation funds in this context.
That is indeed so. People are looking for ways to access funds held in this type of products during this time.
So the living annuity complaints and things like that, you're obviously just directing to the correct ombud to assist.
Yes, they are referred to the long-term insurance ombud, and then from our side, if it's a RA and you're not yet 55 and it's above the 6999 threshold, we just can advise the person that the rules and the act, the Tax Income Act, says that you cannot access this money at the moment. So there's not much we can help with. Sometimes we do get preservation fund queries where the person did not yet access his one, he did not yet make his one withdrawal. And there we can actually then also approach the fund for this to be paid. But most of the times they already exercised that once-off withdrawal from their preservation fund.
Thank you. I think some of what you're going to say here probably will be covered by what Naheem's going to say in the later part of it. Is there anything else you'd like to highlight? Yeah, maybe not some of the points that we've raised here. If there's any just general comment.
Not really. It's just for our own staff. We also have, we are following the necessary guidelines provided to us by government on how to safeguard the staff and how to operate our office during this time.
Thank you. If there are no other, I see there might be one chat. I just want to see if there's no. I think there's a question from Nancy Andrews, but I think that's probably something that Naheem will also cover. The question is, how is the Office of the OPFA dealing with complaints on poor investment return? Belana, we're going to ask Naheem to help us with that.
Yes, that would be good.
Great stuff. Thank you. Thank you. If there's nothing else, Naheem, is there anything you'd like to add at this point?
No, thanks, Wayne. I'm just slightly disappointed I can't show my new hairstyle to the...
Sorry, I'll see you to try and work out the technical stuff in the background.
Just joking, just joking.
No problem. Enos, is there anything you want to contribute at this point before we move on to the next portion of the presentation?
Thanks, Wayne. There's nothing from my side.
Thank you. Thank you, Belana. Naheem, I know this is a new role. Many of us probably know you in a different capacity until very recently. Well, welcome and thank you for agreeing to be part of this discussion. This next section is a very open-ended section, and just something we thought would help the sector to better understand what developments there are at the Office of the Pension Funds Adjudicator, over and above obviously the workload and changes caused by COVID. And if you're happy, I'm going to start with this very general sort of point one. Please, can you provide us with a general update from your office?
Okay, thanks, Wayne. I think it comes at a convenient time for us because we intend implementing a new development fully from the 1st of August 2020 when our software systems are updated. But what it is that we've received a number of representations from various funds requesting an opportunity for them to deal with complaints internally before it is formally investigated by the Pension Funds Adjudicator. And if I can just read directly from one of the letters that we received from a fund that refused to give us a response to a complaint before we allowed them to deal with it internally. The letter said the fund retains a dedicated communication division with a strong focus on resolving disputes even before it gets to the level of a formal complaint. It is important for the fund to avoid friction and to foster a happy membership. Our communication staff members display a very empathetic approach to members and their beneficiaries when inquiries are received. They are proficient in all relevant languages and often visit the concerned members or beneficiaries at their homes in the villages to resolve the concerns raised. In most cases, it is our experience that it is rather a matter of not understanding the situation and the legal framework within which the fund has to operate rather than a grievance. And they then referred us to section 30 capital A1 to 3 of the Pension Funds Act, and the Financial Services Tribunal decision in the Vivian Cohen matter, which also spoke about the jurisdictional requirements before a complaint can be investigated by the adjudicator. So we've taken those representations into consideration. We've also taken into account the fact that funds do have to comply with the TCF principles, and the treating customers fairly principles is going to underpin the COFI bill, and that hopefully will soon become law. And in terms of principle 6 of the TCF principles, customers should not face unreasonable post-sale barriers imposed by firms to submit a complaint. And in that regard, the FSCA has published a draft document for complaints management requirements by retirement funds. In my understanding, that document is going to be redrafted and published again, probably for comment. That was the last I knew, but we've taken that into account, and we've decided that where we receive complaints that have not first been lodged in writing with a fund, we will lodge it on behalf of the complainant with the fund for an internal dispute resolution to take place, and we'll afford the fund 30 days to do so. That's in terms of the Act, and also in terms of the Act, we may even shorten that period if we think if it's necessary, and sometimes we may shorten that 30-day period if we think that the claim will prescribe if we allow the full 30-day period to lapse. And then obviously if it's not resolved, we will then proceed to investigate the matter and follow the usual course. But it's important for funds to respond properly to complaints from its members. That's an obligation placed on them in terms of Section 30A of the Act. And we'll be publishing communication shortly on that. We're just finalizing some of the things, like I said, in our software systems. But there's also another provision in the Act that talks about organizations that have been set up for resolving disputes in the pension funds industry. And that's in terms of Section 30 capital E 1B of the Act. The adjudicator may refer the complainant to such an organization to resolve the complaint first before investigating. Now, I'm not aware of any organizations that have been given approval yet by the FSCA, but if there are, and if funds make us aware of it, we will consider referring the complainants to those organizations, but they're going to have to provide us with proof that the FSCA has approved that. Then you also get, in some funds, you get bargaining councils that deal with certain limited issues pertaining to pension funds, such as arrear contributions, where membership is compulsory, etc. And these councils have to be accredited by the CCMA in terms of Section 143 of the Labor Relations Act. And they can make orders that are enforceable in the same manner that a labor court judgment can be enforced. And if proceedings have been commenced there in an accredited council, we will be precluded from dealing with those complaints because in terms of Section 30H2, if civil proceedings have commenced in another court, we cannot investigate the matter. yeah, that's the latest update from our office. Over to you, Wayne.
Sorry, that's quite a lot, actually. Can we request? Would there is there going to be anything shared in writing soon, or should we just use this presentation and this recording and draft something from the IRF side?
We will be publishing communication soon on our website. Like I said, we need to get our software systems up to date. There is a subscribe function on our website, and I would encourage everyone to go and subscribe to our website so that each time that we issue a communication, they can get updates on or a notification in their emails that we have published something.
Thank you. I'm just wondering, is there channel truth? Maybe I don't know if you can see the Q&A there, Naheem. There's a question from two questions, three now, from speakers. I think I'm going to ask them, and then I'm not sure whether we can answer them now. But if we can't, we can always revert back to on these questions. I think the first two related to complaints around investment returns, which I think you might be discussing later on, if I recall in our preparation. Yeah. And then I think COVID issues, again, I think these are probably more related to 13A contraventions and issues like that, or delay in death benefits. Again, something I think we're going to discuss in broad terms later on. Yeah. Then a different question altogether, and more probably a internal question from Sandile. Looking at the surge in the number of matters that get referred to the Financial Services Tribunal, some based on the error of law, and some based on the error of fact or procedure, will the OPFA consider issuing preliminary rulings to afford parties an opportunity to clarify issues that require clarity before issuing final determinations on the matter? This really worked well during Murphy's days, and this is the practice. The practice this is a practice the PFA office
would we consider it in the future?
Yeah.
Yeah, I think we must understand, firstly, the premise on which that question is based. The surge in the number of matters being referred to the tribunal, I think it's largely because it's actually a free process, whereas before the tribunal was there to deal with these reviews. Aggrieved persons then had to take it to the High Court in terms of Section 30P. So it's not really, I wouldn't attribute it necessarily to errors of law and errors of fact. There definitely will be cases there, but there's also cases where the tribunal dismisses these applications, and we see more of the cases that are dismissed than the ones that are referred back to us for reconsideration. The issue of issuing a preliminary ruling before we make it final, it's probably a good idea, but it's something we'll have to do. We'll have to consider internally. I don't know how Professor Murphy used to run the adjudicator, but I've read his decisions. They're very good, very well reasoned. And I saw that sometimes he's issued interim sort of orders and then given the parties an opportunity to come back. So it's something we'll have to consider, but at the moment, we're not doing that at the moment.
It's not a practice. Good stuff. And then I think just a statement from Geraldine, and I think this is something you're going to address as well, just the statement being the COVID-19 volatile markets have just highlighted again how many members do not understand investments of funds and how their money is being invested. I think this is something we're going to touch on as well, but later. And then another question from Wendy, and it relates directly to 13A, and it says, what is the officer's stance on the delay in contributions and 13A issues and complaints against employers?
Yeah, I think we'll touch on that also.
A bit later, yeah.
Just now, yeah.
Yeah. So I think, can we maybe move on to point 2, related to that? Are there any general trends in complaints that need to be, apologies, I've got my screen highlighted, and what proactive steps can funds take?
Yeah, so I think let me start with what Wendy asked about the 13A, and I'm just going to touch on the FSCA communication that was issued on COVID-19. I'm not going to go into too much of detail on it. I think you did have a previous session, if I'm correct.
That's correct, yes.
So I'm not going to go into too much of detail. But what I'm going to say is that funds must make sure that the rules do not conflict with the provisions of the Act. And in this regard, they need to be aware that there are various provisions in the Act that start off by saying, notwithstanding the rules of a fund. So, and one of these provisions is Section 13A itself. And if we receive a complaint relating to 13A, and the fund is relying on its registered rules, which are in conflict with Section 13A, we cannot uphold the rule and ignore Section 13A. The Act is quite specific there. And also, funds must be aware that there are certain limitations placed on rule amendments, such as in Section 13A4, it cannot be retrospective to the date of the resolution. And we can only uphold a rule retrospective to the date of the resolution if the fund or the particular employer was granted an exemption by the FSCA. Anytime that a fund feels that strict compliance with the Act will not result in good outcomes for its members, then it is entitled to apply for an exemption. And the refusing or granting of an exemption is an administrative action, and the funds can get their own legal advice on whether they should and what remedies are available to them. Our equity jurisdiction will not apply in Section 13A matters. The Financial Services Tribunal held in the matter of Municipal Gratuity Fund versus West Rand District Municipality, which dealt with Section 13A issues. It held at paragraph 21 that our equity jurisdiction cannot override statute. So if funds are going to expect us to apply it, we simply cannot do that. But dealing with what we foresee will become the trends in complaints, I think Pilana explained that there was a drop, but I think now that we've opened up again and we're receiving walk-in clients, we're probably going to see a lot of complaints arising out of the circumstances that we find ourselves in as the result of COVID-19. And I looked for guidance on this from a document that was published by the OECD on Monday, on the 22nd of June 2020. It's titled Retirement Savings in the Time of COVID-19. And they identified challenges that retirement funds across the world will be facing. And firstly, they talk about a decrease in savings due to falling markets. And they talk about an increase in liabilities for the DB type of arrangements, lower capacity by employers and members to pay contributions, operational disruptions due to working remotely, cyber attacks and fraud, and a reduction in savings and compound interest as a result of short-term measures that can have a larger negative impact in the long term, such as contribution holidays and early access. In some countries, they have allowed early access. So some of the recommendations that they make is that members should be encouraged to stay the course, and that communication to members to stay the course and not materialize their losses should be issued regularly by funds. They speak about the 2008 financial crisis, which took 2 years in most countries to turn around. So if possible, I think they're suggesting don't withdraw your benefits or do switches. Allow the market to take a turn. Then they talk about regulatory flexibility, and we should note that that does not equate to non-compliance with the law. In a South African context, I think this can be achieved by the application for and granting of appropriate exemptions in appropriate circumstances. So we still need to comply with the law, but where we feel that it's too strict and it's not resulting in good outcomes for members, then we should look at exemptions. And okay, and then they talk about disclosure to members to the types of scams and frauds that they could be exposed to. They say funds should publish on their website and communicate with their members so that members are aware. They don't give away their details. They don't become victims of cyber attacks and fraud. And then they say in terms of short-term relief, like contribution holidays and early access should be avoided as much as possible because it's going to equate to lower retirement capital and materializing of losses. And withdrawing and early access should be a measure of last resort. So that's what the OECD is recommending. And based on the challenges that they have identified, we foresee that there will be a surge in the number of complaints relating to certain identifiable types of complaints. And the first one obviously is rear contributions. I think I spoke about it just now. Make sure the rules are compliant with the Act. Seek independent legal advice. Where the fund or employer cannot comply with the Act, it should consider applying for an exemption in terms of Section 281 of the Financial Sector Regulation Act. And then complaints relating to a decrease in savings. Now, remember, members rely a lot on the benefit statement that's sent to them, and that waiver that's contained in the benefit statement is often very cold comfort for a member. It's important to communicate with members about fluctuations in the market and how important it is to stay the course and not realize losses. And funds must remember the obligations that are placed on them in terms of the default regulations. And just to recap on some of the obligations in the default regulations, with default investment portfolios, they have to ensure the appropriateness of it. I think the FSCA has recently removed the license of certain individuals that didn't do suitability assessments on their clients before. So I think that's something that funds, boards of funds are going to have to pay attention to, that their default investment portfolios are suitable, that the composition and performance of these default investment portfolios are adequately communicated, that they're reasonably priced, that they are competitive. Fees and charges must be disclosed to the members. Funds must look at both passive and active investment strategies. Do not include loyalty bonuses. There's no lock-in provisions, and that members must be able to move out of these default portfolios at least once every 12 months. And one of the most important things is that funds need to review their default investment portfolios at least annually. But I think in these circumstances, when we expect them probably to do it a bit more often, because there has been these shocks, if I can call them shocks, to the system. And remember, retirement benefits counseling, that's also an important thing. It's almost like such a long time ago that we were talking about this, but it was only last year when the default regulations became the hot topic. But I think with all the developments with COVID, we should remind ourselves about those things. When it comes to operational disruptions due to working remotely, I think funds need to put in measures to ensure that members get a good service. And, you know, when working remotely, it often presents challenges. Even our office is working remotely. On certain days, we're rotating staff. So this may result in delays in payments, probably delays in Section 37C distributions, members not receiving their benefit statements. So I think at the very least, when we receive a complaint relating to this, and if we refer it to the fund to deal with in terms of the internal dispute resolution process, they should be able to resolve it immediately or quite quickly after they receive it. And if they're not able to do it, then I think it's an indication of governance failures, and it's probably something that the FSCA will have to deal with. But yeah, we must try to shorten the processes as far as possible. And obviously, we'll have to understand where there are challenges arising from remote work. On the cyber attacks and fraud, I don't think these necessarily will fall within a definition of complaint in terms of the Act. But it's, you know, for good governance purposes, funds should probably communicate regularly with their members to make them aware that these type of things start to spike in times of financial crisis. And I think the most important theme that came out from the OECD document was that members should stay the course and that funds should communicate regularly. I would say, I would go one step further and say, don't leave it up to journalists to write articles. Funds also have a responsibility to inform their members about what's going on, and specifically within their own funds. Then one other thing I foresee is that in times of a financial crisis, you probably will have a spike in workplace theft, workplace fraud. So 37D, withholding of benefits, I think that becomes an important issue. I've seen a number of complaints since I joined the Adjudicator's office. And in almost every one of them, funds are not doing what they should be doing. We know that in terms of the Highfeld Steel judgment, the SCA said funds can withhold benefits, but they also said you need to do a balancing of the competing interests. And we don't see that balancing of competing interests taking place. Most times, funds are responding to us and saying, the employer has opened a criminal case, we're keeping an eye on what's going on in the criminal case, and sometimes they say to us, even the allegations are supported by a forensic report, but you can't balance the competing interests without having heard from the member. You have to see what prejudice is going to be suffered by the member if the benefit is withheld versus what prejudice will be suffered by the fund, or sorry, by the employer if the benefit is paid out. So that sort of Audi principle applies there. And I think if funds don't do that, they'll be doing the employers a disservice, they'll be doing the members a disservice, and ultimately we'll have no choice but to overturn such decisions. But yeah, that's basically my bit on the proactive steps that funds can take to try and avoid complaints. I'm happy to take questions. Are there any questions, Wayne?
Naheem, there's a statement from Liz saying, "Morning, would it be possible for the OPFA to issue a press statement about members' request requests to preservation and retirement annuity funds, along the lines that the complaint will not be successful due to the nature of the fund and the requirement of the Income Tax Act. Members often seem not to refer to the documentation received and understand the nature of the fund that they are a member of.
Yeah, I think that's a good idea. I'll put it through to the adjudicator and the deputy. But in cases where we don't have jurisdiction, and if another ombud has jurisdiction, we then refer it on behalf of the member to that other ombud.
To the other ombud.
Yeah.
But I think maybe that question of jurisdiction is probably a good one. I know there is information on the site, but maybe in light of people's current needs, it might be beneficial if some of it's sort of nearly top of mind.
Yeah.
I don't know if there are any other questions. I can't see any other questions at the moment. I think that the important thing for me here, there's just a question from David. Okay, all right, so that's just a general question, I think, and it speaks to your suggestion on exemption. It says, what about communication 11 from the FSCA to request funds to change rules to accommodate employers and employees in distress? I think we did discuss that, but maybe worth just revisiting it quickly.
Yeah, I think it's a good initiative on the part of the FSCA, but I think we need to be sure that we are compliant with the Act whenever we're doing something like that. So, like I said, get your individual legal advice on this. Remember, a communication notice is not binding, it's not law, it's simply making you aware of certain things that are going on. So I do think that it's within the fund's powers to change rules, but they need to make sure that they are 100% compliant with the Act when they're doing that. So,
thank you. Then I think we've got two more now, so we've still got some time if you okay with exploring some of them. Of course, again, the proviso being, if we can't answer them now, we'll revert back. From Jürgen, does the OPFS have a view relating to the FSC? Oh, sorry, let me start again. It's a long statement. I don't know if you can see it. Let me read it properly. Does the OPFA have a view relating to the FSCA's interpretation note on Section 37C not being applied when a member has elected to withdraw but passes away prior to the member's election being processed, e.g. money paid out or being transferred to a fund as depicted in the election withdrawal form? Is this not also a manner in which the needs of the member's beneficiaries, dependents, or nominees are being detrimentally affected?
Okay, so I was at the FSCA when we issued that interpretation ruling, and I was intimately involved in that process. So, I can't speak from an organizational point of view what the OPFA's view is on that. I actually haven't discussed it directly with the adjudicator and deputy, but my personal view is that it's correct. I think we went through an extensive consultation process. We took legal advice from senior counsel, etc., and it eventually came out what is already contained there in the interpretation ruling. That I think 37C talks about a benefit that becomes payable upon the death of a member. And if a member makes an election, then it becomes payable as a result of the election, not as a result of the death of the member. So I personally agree with it. But like I say, I don't speak on behalf of the OPFA. I'll have to get a formal view from the OPFA on that.
Okay, thank you. And then hopefully, and I mean, another question from Angus will assist us. I'm just going to read it. It's Naheem, I think it's directed towards you. Your statement on giving an ear to members where the employer has a prior lien. I assume these are the 37D issues we discussed earlier. Say the fund does this and the employer and both the employer and the member say they will suffer desperate prejudice if the benefit is paid, withheld, then what does a fund do? Whose interest is more important?
So I think they're talking about the withholding of the benefits there.
Yes.
And the question is, say the fund does this and to the employer, and both the employer and the member say they will suffer prejudice if the benefit is paid or withheld, and what does the fund do? Whose interests are more important? So, so they're saying if they did a balancing of the interests and both interests are equal. I'm gonna have to say then in that case, you probably will have to look at the purpose then of 37D. 37D's purpose there is to protect the employer, and probably you'd have to then favor the employer in that case. I'm not gonna put that down as a general principle. It's something I probably have to think about a little bit more, but yeah, that would be my initial gut feeling on it. So yeah.
Then Muneeb has a question for you. Surely if the FSCA approves your contribution rule or any rule that has to be compliant with the Act, is one of their duties not to check the compliance of any rule with the Act? So I assume that relates to
yeah, so it is their duty to do that, but you know, behind the badge of the FSCA, there are individual people sitting there, and sometimes they do make mistakes, just like how the adjudicator does make mistakes. And there are cases where the courts have found that rules that have been registered are not compliant with the Act. And in some instances, like I said earlier, the Act is very explicit. It says that it trumps the rule. So yeah, I think that should answer the question.
Okay. I see Angus is unfortunately having difficulty hearing. Hopefully he'll be able to hear it in the recording. Okay. Then another issue here. Sorry, this is becoming a bit of a discussion, but if you don't mind, we'll take it. And if you can't answer, we understand. What is the OPFA's view on the issuing of benefit projections?
Yeah, that's one, Wayne, I'm probably going to have to look at in more detail and come back.
Okay.
Yeah, it's an interesting one. I hope it doesn't create expectations that cannot be met. Expectations in the minds of members that cannot be met eventually. So, but yeah, I'll have to answer that separately.
Thank you. I'm just having a look to see if there are any more questions or queries anywhere else. No, that seems to be it. And thank you for listening to the questions, providing some feedback on the questions. I don't know, Vilana, Naheem, is there anything else you want to share before we move to the close?
Wayne, nothing. It's business as usual.
Good luck.
Yeah, Wayne, I just wanted to say the retirement funds industry is a small industry. We tend to know each other. So just want to say to everyone, take care out there. You know, the health minister said we're riding into a storm. I hope everyone's taking the necessary precautions. Look after your kids, look after your family. And it would be devastating news to hear that one of our colleagues in the industry has succumbed to the virus. And let's hope that isn't the case before some sort of solution to this thing is found.
Thank you, Naeem. I think there were one or two questions we haven't had an opportunity to respond to, but what we'll do is we'll look at them again and then provide maybe just a Q&A in a written form after the
Sure.
session. Thank you. Enos, is there anything you want to add prior to closing?
Nothing from my side, Wayne.
Thank you. Can you close the proceedings for us, please, Enos?
Yeah, thanks, Wayne. Let me also take this opportunity to thank our panelists, the speakers that we have on this webinar today. Thank you for your insights, and also thanks for all those points that you've raised in your discussions. We are delighted that you had time really to spend with us this morning. For participants who still have questions to raise, please, you may send your questions via our email at info@irfa.org.za, info@irfa.org.za. Thank you for your participation, and we will invite you on the feedback. We will expect some feedback from your side on how to improve our service offering. So please, if you have some ideas on how we should improve our service offering, please send it through. Thank you very much.